Hi everyone. Today's session is on the unit that we're going to be doing today is the English legal systems, and my name is Shazia Khan. Today we'll be looking at learning outcome 2, and we'll be looking at understanding the rules of statutory interpretation. We'll be also looking at the different techniques of statutory interpretation, looking at the different, describing the intrinsic and intrinsic aids, and looking at how courts use these aids as well, and looking at the traditional techniques of statutory interpretation with reference to case law. Just go on to the slides. So in the last session, which was learning outcome 1, we looked at the English legal system, how a bill is passed through Parliament, the first stage, second stage, report stage, committee stage, and going through the Lords and the Commons, and then the Royal Assent. We also looked at the difference between criminal law and civil law, and we looked at public and private law with reference to examples. Now we're going to be looking at learning outcome 2, which is looking at understanding the rules of statutory interpretation and the importance of statutory interpretation. So the learning outcome is to explain the traditional techniques of statutory interpretation and how they are used, and to describe intrinsic and extrinsic aids. So 2.1 we'll look at the explaining the traditional techniques of statutory interpretation, how they are used, and what statutory interpretation is. So the whole aim of statutory interpretation is to arrive to a legal meaning of legislation, or in other words, the meaning that conveys the legislative intent. The primary indication of legislative intent is the legislative text, reading context, and having regard to its purpose. So it's really important that we when we use statutory interpretation, we look at things where there's complexity, uncertainty arises as to how the law applies in every given situation. So an introduction to statutory interpretation is statutes of law, also known as legislation, are the written laws of the United Kingdom. They are created and implemented by Parliament and enforced by various authorities, prosecuting bodies, etc. They're implemented by Parliament through, if there are any laws to be passed, they go through the issue of the law being passed through the process, which we looked at in learning outcome 1. And then we looked at the issue of how the law is implemented and enforced as well. So interpreting a meaning of legislation, not always straightforward, and in some cases the judges are called upon to interpret legislation in accordance with existing law and the rules of statutory interpretation. Statutory interpretation may be required where complexity and uncertainty arises as to how the law applies in any given situation. Those who draft legislation do their utmost within their extraordinary experience and drafting skills to craft legislation that is clear and unambiguous. However, sometimes the written law is not always clear. Typical problems include a failure within legislation to cover a specific point, ambiguity as to its meaning, drafting errors, new developments and changes in the use of law. So changes in the use of language. So there are rules of statutory interpretation, and there are 4 main rules that apply in statutory interpretation in regards to interpreting the law. When we talk about the law, the problems being, there are problems with the ambiguity in law, any sort of changes in language and things, we have to bear in mind that some statutes are 100 years old and the language used in them may have a different meaning today in society. So we need to identify that. And statutory interpretation is strictly a court's matter. Some of the rules that the courts may follow when including legislation would be things like the literal rule, the golden rule, the mischief rule, and the judge's discretion, and we'll go through each one. So the literal rule, under the literal rule, the words in a statute are given their ordinary and natural meaning. This means that the laws are read literally and there's no need for further analysis. They will read literally and do not need, as I've explained, further analysis for different meanings, disregarding the plain words of the legislation. An example of a plain reading resulting in a harsh result is the Berryman case in 1946, where a railway worker was killed while doing some oiling on a railway line as a result of there being no lookout point. The judge would not grant Mrs. Berryman compensation for her husband's death, as the relevant act only stated that lookout points had to be issued for workers relying or repairing the line. Oiling did not come within either of the two categories. This result was clearly harsh and unjust. To overcome such outcomes, the golden rule was introduced to modify the literal rule. So the golden rule. The golden rule is used to prevent inconsistency and absurdity when interpreting an act literally. It can be applied narrowly or widely. Under the narrow approach, the court can choose between the possible meanings of a word. If only meaning is apparent, that meaning must be adopted. In the case of Alder and George 1964, the defendant was charged under Official Secrets Act 1920 with obstruction in the vicinity of a prohibited area. Although the defendant had carried out the obstruction inside the area, the court did not restrict itself to the literal wording of the act and found him guilty. Under the wider approach, the courts can modify the words in order to avoid a problem, for instance, where there is an obvious and clear meaning, but this meaning would lead to an absurd result. For instance, in the case of Re Sigsworth, 1935, the defendant had murdered his mother. Under the relevant Act of Parliament, the next of kin would inherit the deceased estates. Whilst this was clear, the literal rule would produce an unjust result. The golden rule was applied so that the next of kin would not inherit the estate where they had killed the deceased. The mischief rules. Sometimes statutes can be defined more broadly by the courts to deal with unforeseen loopholes or ambiguity within the legislation, which may prevent Parliament's original intention being honoured. This application is known as the mischief rule and will be used where there is ambiguity, and the mischief rule was laid down in the landmark case of Hayden's case in 1584, where the court said 4 issues need to be considered when interpreting statutes, and these are: firstly, that they examine the common law prior to the act. Secondly, that they locate the mischief or defect in the common law. Thirdly, that they identify the remedy Parliament meant to propose to eliminate the mischief and to give effect to that remedy. Fourthly, The mischief rule is narrower than the golden rule and only applied to determine the mischief and defect the statute was intended to remedy. The rule gives a judge more discretion than either the literal or golden rule. The main advantage of the mischief rule is that it closes loopholes in the law, as stated earlier, and allows laws to develop. The main disadvantage is that it creates a crime after the event has taken place, which can be seen in the case of Smith and Hughes, 1960. In the case of Cockery and Carpenter, 1951, Section 12 of the Licensing Act 1872 made an offence to be drunk in charge of a carriage on the highway. It was held that the court applied the mischief rule, holding that a riding bike was within the mischief of the act, as the defendant represented a danger to himself and the other road users. Then we go on to the judge's discretion. Judges have the discretion to apply any of these rules of statutory interpretation as they deem appropriate. Each of the rules has its imperfections, but it provides judges with the ability to interpret legislation in the best way possible to achieve the result as intended by Parliament when it was enacted. These rules of statutory interpretation provide a coherent and proven framework for the courts to follow to achieve the best possible outcome of a case in accordance with legislation. In exercising these discretions, judges can use both intrinsic and extrinsic aids such as Hansard and other statutes, law commission reports and royal commission reports for the purposes of interpreting legislation. This reduces the risk of statutes being interpreted in a way that contradicts other legislations. Judges have the discretion to apply any of these statutory interpretations they deem appropriate. So now we're going to go on to looking at describing 2.2, describing intrinsic and extrinsic aids. So intrinsic aid, extrinsic aids are matters which may put an act into context. They are considered, they are things found outside the actual state statute which may be considered by judges to help them understand the meaning of a statute more clearly. The following intrinsic aids have been regarded as acceptable: the long and the short title, the preamble, definition sections, schedules, and headings. Intrinsic aids, the advantages: it is more respectful of Parliament to look elsewhere in the Act rather than outside the Act. It is quick and easy to look at things like marginal notes, which are helpful in Tivnan, or at the long title used in the Cornwall, CC and Baker case. Some internal aids like interpretation sections and schedules are designed to provide definitions and explanations, so it's common sense to look at them. For example, Section 10 of the Theft Acts explain the meaning of weapon of offence. Intrinsic aid disadvantages: problems with wording are not likely to be solved by looking elsewhere in the Act, especially if the words are ambiguous, as in Allen, or very plain but wrong, as in the case of Whiteley and Chapel, 1868. And in this case, this led to an absurd result. A section made an offence to impersonate any person entitled to vote. The defendant in this case had impersonated a man who had died, therefore rendering that person not entitled to vote. The act relating to voting rights required an individual to be living to be entitled to vote. In the case, the literal rule was applied and the defendant was thus acquitted of any wrongdoing. Internal aids alone are unlikely to be sufficient, and if judges were not allowed to refer to anything outside the Act, it would be more difficult for them to avoid unfair or absurd decisions. Extrinsic aids. These are matters which help put an Act into context. These things are found outside of the actual statute, which may be considered by judges to help them understand the meaning of a statute. The following are intrinsic aids which have been regarded as acceptable. So dictionaries and legal textbooks. Other statutes, reports to the Law Commission and other law reform bodies, international treaties, explanatory notes. Other things could be things like textbooks, as we mentioned earlier, academic writings, case law from other jurisdictions, and Hansard as well is really important in intrinsic aids. Intrinsic aid sources, dictionaries and legal textbooks. Dictionaries are an obvious tool to assist with the literal rule. Other statutes, earlier acts have relevance in tracing the mischief that an act was designed to tackle. Reports of the Law Commission and other law reform bodies. So an act is often preceded by an investigation by one of the bodies set up by the government to investigate options for reforming the law. These bodies produce reports on their findings and recommendations, which the government may adopt in a bill. International treaties. It is presumed that the courts that Parliament does not legislate in a way that would be a clear breach of a treaty signed by the United Kingdom government. Explanatory notes. Acts passed since 1999 have been accompanied by explanatory notes. These notes summarise the main provisions of the Act and explain the background to the Act. The government department responsible for the legislation writes them after the Act has been passed. For this reason, they should be regarded as intrinsic aids. Intrinsic aids advantages. Using a dictionary is quick and easy, as in the case of Cheeseman and Waghorn. Using Hansard might clarify that Parliament meant what Parliament meant. This is a case of Davies and Johnson, where Lord Denning said that not to use it would be like groping around in the dark without putting the light on. Europe allows background papers to be used, so it is sensible for English courts to use them when acts are based on international rules, as such as the Fothergill case and Monarch Airlines. Intrinsic aids disadvantages. So using Hansard may not reveal what Parliament as a whole intended. Pepper and Hart restricts the court in considering what ministers said, but what Parliament may have decided not to follow in the minister's view. What the minister said may not be clear. In the case of Deegan, court ruled that Hansard couldn't be used because what the minister said was not clear. Lord Bingham said if the statement is unclear, the courts would be tempted to compare one statement with another and run the risk of questioning proceedings in Parliament, which constitutionally they are not allowed to do. Danger of treating materials that are not part of the Act as having the same status as the Act and therefore undermining the authority of Parliament. This is the main objection to use internal aids, particularly those other than dictionaries which are less objectable. In the case of Pepper and Hart, the move from the literal to the purposive approach is described. The courts now adopt a purposive approach which seeks to give effect to the true purpose of legislation. So in simple words, the words of legislation should be understood in the terms of the purpose of legislation. To identify the purpose, a judge should be able to look beyond the words of an act, for example, to contemporary social factors. The pendulum has swung towards purposive methods of construction. Exercise. So in regards to researching for the doing some research around the cases in regards to the intrinsic and intrinsic rules, but also looking at the purposive, literal and golden, and the judge's discretion. Look at the following cases which will help and support you, and this will be homework for you to consider. Case of Alder and George, 1964. Look at Hansard statute. Look at the case of Cornwall, CC and Baker. Whiteley and Chappell, 1868. Cheeseman and Vaughan. Davies and Johnson, what Lord Denning stated in that case. Also look at Fothergill and Monarch Airlines and Pepper and Hart, which I identified a little bit in regards to the facts of the case just previously. So a mind map for the exercise. So when you look at the intrinsic and extrinsic aids, this mind map will help you identify things such as when you look at intrinsic aids, you've got the issue in regards to the use of dictionaries and used to find the literal meaning of words, as in the Vaughan literal meaning of the case. And then Hansard, so this looks at issues in regards to debate notes. And then you've got the reports from Law Reform and Law Commission, which highlights what is wrong with an act. And then you've got previous version of acts. So in regards to looking at the substance of the act, then you've got Interpretation Act, provides legal definition for any sort of work that's used. Internal treaties, so use the principles of the act. Textbooks refer to the guidance, and then you've got explanatory notes, again used to explain certain points of an act since 1999. However, they are not inside the act, hence the intrinsic forms of aids. Then you've got the intrinsic aids, which are long, short title of the act. So that looks at things like Abortion Act 1997, the long title examined for the words. And then you've got preamble, which sets out the purpose of the act, usually precedes the main body of the act. And then you've got definitions of the act, which explain the meaning of the specific words used in the context. And then you've got the schedule of the act, which additions to the main body of the act, which makes it more understandable. And then the punctuation, so can change the meanings of a particular words used in a literal sense. So these are the intrinsic aids and the intrinsic aids that are used, and you could use these in regards to the cases that you look at, and also the importance of these aids in regards to statutory interpretation, and when judges identify why there's a need to use these aids to help support them. Okay, we've finished the session now on statutory interpretation, and these are some of the references that you could look at in regards to trying to help you with doing the exercise that I set with the case law. So you've got the UK public law and European law, HARP publishing. You've got the review of economic dynamics, principles of criminal law, the interpreting precedents, the rule of law, and the Derbyshire English legal system. You've also got Elliott and Quinn English legal system, which will help you in regards to researching the cases. You've also got the Hodder principles of criminal law. You've got the interpreting precedents, Sweet and Maxwell, Penny Derbyshire. So have a look at these. These are some of the references that you could use in regards to doing your exercises, but will support you when it comes to doing your assignment for this session in regards to learning outcome 2. We've finished learning outcome 2 now, and the next session we'll be working around learning outcome 3. We've covered the different types of, in today's session, we've covered the different types of aids that I use, the different types of rules that I use, such as the rules used, which are golden, literal, what statutory interpretation is, the different types of rules which I mentioned, literal, golden, mischief, and the rule where the judge has the discretion. And we also looked at case law in regards to this, and then we looked at the intrinsic and extrinsic aids, and also looked at the advantages and disadvantages of this. There are more case law available for this on Moodle, so there's lots of additional reading that you need to go on to Moodle to complete this module, and also to complete the learning outcomes when doing the assignments. So please refer to Moodle for additional resources and additional reading that you can do in regards to statutory interpretation. Thank you for attending today's session.